First, a bit of history. This whole saga starts with a 1984 case called Chevron versus the Natural Resources Defense Council. Back then, fishermen sued because they had to pay for observers to monitor their catches. The court ruled that federal agencies could interpret laws as long as their interpretations were reasonable. Fast forward to just last month in July of 2024. The Supreme Court handed down rulings that could change the game entirely. According to Overdrive, these new decisions could limit the power of federal agencies like FMCSA and the Environmental Protection Agency to create regulations. This shocked me. Courts used to assume federal agencies knew what they were doing. But if you've ever felt that the disconnect between rule makers and actual truck drivers is massive, you're not alone. So, how does this impact trucking? Well, the FMCSA has often relied on a rule called the Chevron defense to push through regulations, like the mandate for electronic logging devices, ELDs. This defense let them argue that their interpretation of the law deserved leeway. With the new ruling, courts might not be so lenient, meaning agencies will face more scrutiny and might find it harder to impose new regulations. Carriers would have more power to challenge regulations, creating less of the back and forth we usually see whenever the executive branch changes hands. Overdrive gave an example to illustrate this. Imagine Congress passes a law about testing and treating sleep disorders for CDL medical certification, but doesn't clearly define what a sleep disorder is. FMCSA might interpret this broadly, forcing drivers to undergo expensive sleep tests just for taking naps. Before, courts would side with FMCSA, assuming they knew best. Now, courts might side with drivers instead. This shocked me. Courts used to assume federal agencies knew what they were doing. But if you've ever felt that the disconnect between rule makers and actual truck drivers is massive, you're not alone. That's not all. The Supreme Court also tackled the statute of limitations for challenging regulations. Before, you had 6 years from when a regulation took effect to challenge it. Now the 6-year clock starts when you're adversely affected. So if a rule was put in place in 1950, but you're affected in 2024, you have until 2030 to challenge it. This could open the floodgates for lawsuits. So how will this all play out? Only time will tell. Courts could be swamped with cases, and federal agencies might start reevaluating their rules to see which ones would hold up in court. This creates a bit of uncertainty in the short term. I hope this clears things up a bit. If you have more info or insights, drop a comment below. I'd like to hear from you. We are Registration LLC, the #1 online service provider for the transportation industry. Please visit FMCSAregistration.com or please call 866-477-0707.